This is the fourth and final video covering the change in patent law to first inventor to file. Here we will cover the exceptions to the prior art that we talked about in the third video. There are three specific exceptions that we need to talk about. Keep in mind that these exceptions apply only to disclosures made in the documents we talked about in the third video. Those documents are a U.S. patent, a published U.S. patent application, or a WIPO published PCT application. They must name another inventor and must have filed before the effective filing date of the claimed invention, but not issued or published until after the effective filing date of the claimed invention. So just remember that as we move through. Ready? Okay. Here's an exception-by-exception look at this area of the law, officially called 35 U.S.C. 102, Section B, Subsection 2. It's broken into three parts, A, B, and C. Part A says a disclosure in any of these three documents made by someone else who acquired the claimed invention's subject matter from an inventor will not be considered prior art against the claimed invention. Part B says that a disclosure made in any of these three documents would be excluded from prior art if the subject matter had already been publicly disclosed by the inventor or another who obtained the subject matter directly or indirectly from the inventor or any co-inventors. However, if the subject matter was disclosed more than 1 year before the effective filing date of the claimed invention, it would be prior art under Section 102A1, which we covered in the first video. Finally, Part C states that these documents are not considered prior art against a claimed invention if it and the disclosed subject matter were owned by or under an obligation of assignment to the same person before the effective filing date of the claimed invention. Okay. So what does this mean for you? Let's say you file a patent application for a claimed invention. Let's also say there's another published U.S. patent application that contains a disclosure of your claimed invention's subject matter. If that application names any inventor other than what is listed for your claimed invention and that application was filed before your effective filing date, then it could be prior art against your claimed invention. But hold on. Let's check the exceptions. Was the disclosure in the published application obtained from you or a co-inventor? Then it may be excluded as prior art. Or, before the published application was effectively filed, had the subject matter already been publicly disclosed by you, a co-inventor, or someone else who obtained the subject matter from you? If so, then it may be excluded as prior art. And lastly, did you own or were under an obligation of assignment to both the disclosed subject matter and the claimed invention before you effectively filed your claimed invention? Then the published application may be excluded as prior art. All right, that's a mouthful, but if you still have questions, you can view a more in-depth discussion by selecting the link at the bottom of this video. This concludes our coverage of the America Invents Act change to patent law from first to invent to first inventor to file.